All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. We're here for oral argument in our cause number CV24-0002, Toma et al. Versus Fontes et al. These proceedings are being video and audio recorded and live streamed, so we ask counsel please identify yourself and your client at the beginning of your argument. Each side will have 25 minutes. Mr. Johnson, you're responsible for watching the clock to reserve a portion of that time, if desired. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, Mr. Johnson, you may proceed.
May it please the Court. Brett Johnson, with me today is Tracy Olson on behalf of the President of the Senate, Warren Peterson, and the Speaker of the House, Ben Toma. Judge Gatlett, I'll watch for my 6 minutes I'm hoping to hold for rebuttal. The legislature comes before you today to address Proposition 211 and to preserve the balance of power between the branches of government in the state of Arizona. As recognized repeatedly by the Superior Court, this matter is of the utmost importance to the state of Arizona and to ensure fealty to and full force and effect of the Arizona Constitution. To be clear, we are not here to debate the policies underlying Proposition 211, but instead pushing back on the facial challenges to the legislature's authorities. The parties have spent a significant time discussing various canons of construction, but the reality is that you do not need to get to those canons if the plain language is not ambiguous. Here, the plain language is not ambiguous. Your Honors, turning first to our first facial challenge is based off of the separation of powers. Primarily dealing with ARS 16-974A and D in its entirety, 974D restrains the legislature by precluding it from exercising its constitutional authority to enact policy, amending and implementing rules adopted by the Commission. On the other hand, you have 16974A, A1, and A8 that has language that may assist language that allows the Commission to exercise virtually unlimited, unchecked power to adopt legislative rules that are not strictly tethered to the text of the statute. Together, these provisions interrupt the Arizona Constitution's balance of power. The Commission is making policy decisions.
On A8, legislature pretty frequently delegates authority to administrative agencies, and when that happens, we don't usually see lawsuits by the legislature challenging prior delegations. We do hear, I was wondering, does the legislature standing turn on the fact that the delegation in this particular case was enacted by the people versus the legislature itself, or are you taking the position that the legislature could challenge prior delegations by prior legislatures?
Well, Your Honor, I think that the first step on prior delegations of prior legislatures is that the first effort would be to obviously change those laws through the legislative process. But in this context, actually bringing up 974D, their ability to actually effectuate change, whether underneath the Voter Protection Act or exercising its Article 4 powers, is limited. And if the people, sitting as the legislature, wanted to do that, the appropriate route was to get a constitutional amendment, not do it through the legislature. So in this confines, whether just because the people have delegated certain rights and authorities to the Commission does not mean that those still should not be constitutional in effect and in use. And that is why the legislature has standing here, especially because its powers under Article 4 are limited. It is a shared power.
I understand your argument about standing vis-a-vis 974D, and I don't know if I used vis-a-vis correctly there, so if I didn't, I apologize. But I don't understand the A8 argument. It seems to me that the people that would have standing there are people who are directly affected by some rulemaking that they claim violates delegation or non-delegation principles, not the legislature
Well, Your Honor, that's the core of the separation of powers. When an executive agency, in this case the commission, is delegated authorities that should have been reserved to the legislature or provided some sort of rail guards on the non-delegation, the legislature has the ability and the standing under Article 4, Article 3, because we have the judiciary of case and controversy in place. They have the ability to stand up and say that is not an appropriate delegation to the legislature to the commission by the people. They have standing, especially if you're talking about the rules specifically, both the Senate and the House passed rules that allowed this type of case, especially when the rights and duties of the houses are in effect. And that's exactly what we're dealing with here.
But A8 doesn't prohibit the legislature from passing or making laws dealing with campaign finance disclosures. Standing by itself. Now, the VPA may prevent.
Well, I think that the legislature does have a larger role to ensure that the laws that are passed and done, especially by an agency, have some constitutional meaning. And if you look at 974A, in relation to A1 and then AD or A8, those are all within the confines of what the legislature would normally hand out to specific areas of the branches of the government, whether it be the judiciary or to an executive agency. But without the guardrails that are in place, especially when read in context of 974D, that is where the violation occurs. So it's all rules for A1 and then any rules that could effectuate this chapter within A8. That is what is.
So let's drill down a bit on that. If the legislature wanted to challenge, for example, the delegation it made years back in the EPM statute because it no longer likes it, would the legislature have standing to do that at this point?
I think that the legislature does have standing to ensure that the Constitution is followed, as well as the previous statutory frameworks. And if, in that case, the Secretary of State, Attorney General, and the Governor went outside the confines of what was statutorily available, then I do think, and there's Supreme Court precedent on that the legislature should be able to step in and say, wait a minute, you are utilizing our authorities in an inappropriate way.
How about in the emergency management statute, which I think you may know?
I know.
About. Could the legislature say we're no longer happy that when the governor declares an emergency, he or she gets to exercise the full police power, and therefore we're going to bring a declaratory judgment asking for that delegation to be struck down on its face?
Well, under Title 36, the legislature, both the Senate President and the Speaker of the House, have authorities through, in that case, the Security Council to be able to bring together, and if they do not like something that the governor in that context is doing, I think underneath that statute that the legislature does have the authority to push back and say Title 36 is being abused, if that is the context.
Well, I think that's a little different, though, than just saying on its face, we no longer like the delegation in the statute, and therefore we are going to bring an action challenging it under the non-delegation doctrine. Would the legislature have standing to do that?
Under the plain reading of that statute in particular, no, Your Honor. But in that statute, it's not limiting what the legislature can do. In fact, in that statute, the legislature has powers to come back into session and correct whatever is happening, including removing the declaration of emergency.
Which
not in this
goes back to
context.
my first question. But for 974D, would you have any standing here to challenge 974A?
So hypothetically speaking, if we were to just say D does not exist, do you still have standing under the A argument?
I think we do. The legislature does, Your Honor, in the context because 97A in its entirety is unconstitutional. Just the fact that it was done by the people, and I appreciate this is a case of first impression, but the legislature, standing as a branch of government, has an obligation to ensure that the laws are properly constitutional, especially when another either whether the people as the legislature or the executive or the judiciary is pushing back on the legislature's authorities and it's not a constitutional amendment like the Voter Protection Act, then the legislature has the ability to step up and say that is a violation of Article 4 of the Constitution because it infringes on the rights of the legislature to effectuate policy within the state of Arizona. And that is what 974A does.
It feels like the legislature doesn't have the votes to amend a particular delegation that was made in the past that it no longer likes. So we're now instead opening the courthouse doors to non-delegation challenges by the legislative branch. That causes me a little bit of heartburns. How do you address that?
Your Honor, obviously each of those cases is a case-by-case basis, and I would necessarily agree that between 1940 and the Roberts case that there are a lot of different laws back to the Lochner era that probably have some suspect basis underneath a current Arizona statute. But when you're looking at this statute in particular, it is definitely an affront on its face to the Arizona legislature's power. And just the fact that it was done by the people acting as the legislature does not remove its ability under Article 4 and Article 3 to say that there is now a controversy of a statute, not a constitutional amendment, that is infringing on the rights of the legislature. That is what this...
So delegation is, non-delegation, or how we apply it, is different for initiatives than it is for regular legislation?
No, Your Honor. I think that it applies... I think it applies equally for the concept of non-delegation, the non-delegation doctrine, but I think what the conversation here is, does it matter whether or not that is brought by the legislature, a challenge to non-delegation is brought by the legislature, or is there some sort of constitutional provision that limits the legislature's ability to bring a suit when their powers are being infringed just because it was brought by the people? And I'm not aware of any case that says that specific thing, that just because it's brought by the people and given the power to the commission.
But that's where I'm losing your train, is because then all delegations are suspect, because anytime an agency is empowered to do anything would be
And I don't disagree with you, Your Honor. If the people decide to put through an initiative without
I'm saying either it's only because of the overlay of the VPA on this proposition that creates a problem, or any delegation is automatically constitutionally suspect.
I'm not saying automatically suspect. Obviously, it's a case-by-case basis. And for example, would the legislature have to stand by if the people decided to reinstitute slavery into the state of Arizona or segregation in schooling? I don't think that the legislature would have to stand by and allow those clearly now unconstitutional actions to occur. I think the legislature has a duty underneath Article 4 and Article 3 to stand by and protect the constitutionality, definitely when there's an institutional challenge as here. There's an institutional injury as to the legislature that should have been a constitutional amendment. That is the fault of this initiative through the parameters throughout all of the arguments.
How would you articulate the test for institutional standing for the legislature?
The institutional standing is that if it affects the powers and duties underneath Article 4 in this context for purposes of the legislature, then the legislature has standing. So if you're taking away a power, you're limiting their rights outside of the constitutional amendment, in this case the Voter Protection Act, then the legislature has the ability and standing to stand up. And
well, that's maybe I'm just dense, but then that goes back to, I don't see how 974A impacts your authority, except for the fact that it's Voter Protection Act.
Well, we obviously have D, which I'm thinking from the scenario that we're not talking about D, but for purposes of A, under the Voter Protection Act, the legislature would still, obviously in the context of how this is written, the legislature would still be able to, if it was in furtherance underneath the VPA or to a 3/4 vote, would be able to make change to the initiative to, quite honestly, using this context, to fix a lot of the items within this statute that the commission, in fairness, is trying to do. They call it clarifying, but in reality it is rewriting what the initiative is. And that is the main area of where the legislature is able to step in and say, whether it's protecting the people's right to initiative, that the commission is going too far now in trying to clarify what the people wanted, or that taking away the legislature's power in both those.
Right, but that's all the D issue, not the A issue.
Well, it's not, Your Honor, because if you look at A1 through 8 and A, all of it in totality, what is it? It's a super legislature, right? It's issuing rules without, number one, it's issuing rules without any kind of constraints. That's in subsection 1. You then get to the ability to do investigations and enforcements and hearings. Quite honestly, that's judiciary, but where does the judiciary get its power outside the Arizona Constitution? It learns where the policy is from the legislature. And then you have this catch-all in 8, which says anything in furtherance of the chapter without any kind of guardrails going to the whole non-delegation issue. So that is why, from that context by itself, the legislature is able to step in and say there are no super branches underneath the Arizona Constitution. Arizona is unique in that context of Article 3 that we have a separation of powers. Now, I concur, and we talked about at the Superior Court level, can there be some overlap? Can there be filling in the gaps? Does it have to be a mathematical formula? Absolutely not. But the clear line is when a commission or an agency is able to set the policy of the state of Arizona, especially in the context of First Amendment rights, the Elections Clause, which is underneath the Arizona Constitution, and again, delegated to the legislature to pass laws in that context. When you're infringing on those rights, the legislature does have the ability to stand up and say that is a violation and it's going to upset the balances between the different branches.
Has the commission exercised authority under A8?
Yes, Your Honor.
We have three rules in front of us, and I think those would fall under A1, right?
Well, in regard to creating advisory opinions and giving that safe harbor, I don't think a safe harbor would necessarily be in the context of A1. I think A8 would be also that safe harbor that is nowhere within 211. So if somebody goes to the commission and they give them an advisory opinion, again, nowhere in the statute whatsoever, and the commission says, hey, we agree with you, you have a safe harbor. What the commission has completely failed to appreciate, though, is the individual private complainant also has the right to go to the court and say the commission's wrong.
Well, and ordinarily, the legislature could step in and pass a statute that applies to all administrative agencies saying you cannot extend safe harbors based on advisory opinions. The legislature no longer has the power to do that here, but that's because of D, right?
That is primarily because of D. But you also have to look at the any and the may. Inside 974A, you have, in the main section, you have any, and then in 8, you have any. So within that prerogative, we don't know what the limits are in just of 974. And that's what I think is the problem by 974 by itself, is that there are no parameters as to what the commission can and cannot do. Especially when you look at 1, and going to the non-delegation aspect of it, it just says pass rules and regulations with a period at the end of it. There are no guardrails to say, in furtherance of the administration of this act, putting together some forms. Those are all also covered in different provisions. That is what is fundamentally wrong with the initiative itself. So it is D.
Well, and a statute saying no safe harbors would probably be consistent with the VPA because it would further the purpose of the campaign finance disclosure laws, right? It would make them more stringent because as a regulated party, I could no longer rely on the safe harbor.
That's a different provision, Your Honor. That's 978, and that's where the commission wants to kind of bifurcate the concept between legislature and legislative bodies. Obviously, there's no basis for that. A legislature is a legislative body, but under 978, you wouldn't have to rely on 974A8 to do that because that's already in 978. But in the context of that in particular, talking about the Voter Protection Act, the Voter Protection Act talks about 3/4 and in furtherance of the statute or the initiative. Well, 978 only limits it is a VPA plus. It's a VPA on steroids because it says only if it is now more stringent than what the commission's rules are does the legislature have the ability to make change. So one other area, and I think this might be where some of the conversation is going, is this is not severable, if that's what the context of the court is going towards. The people were promised this initiative, but they were promised an unconstitutional initiative. And it's not this court's role to rewrite the statute and strike out 974D for the purpose
of... If the people voted on and included an express severability provision, doesn't that a pretty clear textual indication as to what the people intended here?
Well, we don't know for sure, Your Honor. And under Doe, which Your Honor is familiar with, as well as several other provisions, the court is not in the business of rewriting it. But underneath the test for severability is, number one, is it workable, and is would the people have voted for it? And inside the pamphlet, which we included for you, and in the ballot itself, it specifically delineated. It told the voters when they were going into the polling location, the commission is the one who's going to be setting these rules and regulations. intent. It said it was going to be the primary agency who was going to be effectuating this initiative. That is what the people wanted. But just like if anything else is unconstitutional, I mentioned slavery earlier, just because the people voted for something of that nature does not make it constitutional. And because this is an institutional injury, the legislature is able to step up and say, the people do have that right. They voted on something. It is unconstitutional. The court should not run in and save an initiative that's clearly.
So are you arguing then that severability clause in a initiative or in regular legislation is almost an unconstitutional delegation to the courts?
In some contexts, Your Honor, I think the Myers case was at least one example, also the Clean Elections Commission case, where whole segments could have been taken out from an administrative standpoint without causing a problem with a different statute. So I think in the context of purely administration, but if you took out 974A and you took out 974D, but all the reporting requirements and the opt-out provisions and everything else that is in 974, how are you going to enforce it? You can't enforce it. So the whole purpose of this, the Proposition 211, was to set up this framework and ensure enforcement. With that, Your Honor, may I reserve the rest of my time. Thank you.
Good morning, Your Honors. May it please the Court, my name is Eric Frazier. I represent the Arizona Citizens Clean Elections Commission. And a quick housekeeping note, the defendants plan to divide the argument by topic, so I will cover the merits with you first, and then Mr. Aerosmith from the Attorney General's office will discuss standing with you. So I plan on reserving about
the other way, but this is fine.
I appreciate that, thank you. Well, we will, I plan to reserve about 8 minutes of time for Mr. Aerosmith, and I'll watch the clock. And if you think you need more time with him, I'd be happy to give him however much time you think is appropriate.
It wasn't the timing, it was the order.
I understand. On the merits, though, since I'm here, this is a facial challenge, which means that the plaintiffs can prevail only if they can show that there is no constitutional application of these statutes. It is not enough to find that some possible applications might be unconstitutional or speculate about some actions that the commission might take. They have to show that there is no constitutional scope at all, and they can't meet that burden. So I'll start with A8, which is a catch-all provision. And I'd like to give you a common sense example. So imagine I authorize a babysitter to give my kids dinner and play a game with them, watch a movie with them, or, and here's the important part, do anything else that the kids might want to do. That catch-all provision would authorize the babysitter to do an art project with them, but it would not authorize him or her to take my kids to California and go to Disneyland. That's because textualism is not literalism, and we know how to interpret what these catch-all phrases mean. So even if taking the kids to Disneyland would literally fall under the catch-all phrase, anything else the kids might want to do, that's not how we interpret these in everyday speech, and it's not how courts interpret them. We have interpretive tools like a jus des generis. We know how to interpret these things. They have a natural scope and a natural limit. These catch-all phrases are almost like in a template for legislation. They're used everywhere throughout the statutes.
Are there other statutes that use the term like or similar to may assist?
Yeah, well, first of all, the permissiveness does not create a constitutional problem.
Well, I think his question was, are there other statutes that use this language? Because I did some research on Westlaw, and I'm not the expert on it. I couldn't find anything that mirrored this exact language.
So ARS 40-336 has may, and it authorizes an agency, that the agency may perform, quote, any other act which health or safety requires. But again, the permissive...
Doesn't that, which health and safety requires, doesn't that
Limit it.
provide or limit the scope of that delegation?
It does, and so, there are...
Similar here?
Sure, so we have, I mean, this other example that I can give you doesn't have the word may in it, but ARS 48558A says any other act, which actually does have may, which may become necessary or proper to carry out the intent and purpose of the statute. I think the point is that these things have a natural limit, and you don't need that natural limit to be precisely in the text because we have other contextual canons that courts apply every day to define and limit the scope of these provisions.
So your argument is A1 through 7 limit the scope of 8?
A1 through 7 and the introductory sentence of A itself. And I mean, that's
So
block.
I guess, in your mind, what is the limit then to A8? You could articulate that for me based on A1 through 7.
Sure. So, I mean, I think the big picture point is that this is a standard catch-all phrase that we apply the normal limits to that. So here, A8 gives authority to do other types of ordinary agency implementation of Prop 211. That's the correct interpretation. Other types of ordinary agency implementation. Because everything in 1 through 7 is exactly that. It's implementing Prop 211. And the introductory sentence, the Commission is the primary agency authorized to implement and enforce that chapter. 1 through 7 all follow that. And the court has to look at the statute in context. This year, the Arizona Supreme Court said in Drummond that context is a primary determinant of meaning. And last year before that in Marana, the court said that the plain meaning of the words in their broader statutory context is how we do textualism here.
Do you agree that the Commission has exercised its authority under A8? I mean, that at least one of the 3 rules here is Part A1, Part A8, I guess?
So I think the 808, the advisory opinion rule, I don't remember whether they expressly invoked A8, but I think A8 would authorize the advisory opinions rule. But again, on a facial challenge, the question is there any permissible application of the statute?
How does the advisory opinion rule satisfy the standard you articulated for A8?
Because that would assist in implementing and enforcing this chapter to give guidance to regulated parties. The advisory opinions essentially combine 2 things. They combine, number 1, announcing the agency's interpretation of the law to regulated parties, which I think there's no question an agency can do that. We could put a thing on our website saying, here's how we interpret this law. And it combines that with announcing in advance prosecutorial discretion. So those things would help in implementing the statute and enforcing the statute.
Would you agree that if we took 974D out of the picture, and I'm not saying that we're going to, I'm just saying hypothetically, that the legislature could then say, you know what, we don't like safe harbors, and we think it runs counter to the intent of Prop 211, and therefore pass a law that would say no safe harbors?
So that would have to satisfy the Voter Protection Act, of course, and I think the question there is, assuming that the legislature had a supermajority vote, would that further the purpose of Prop 211? And I don't have an answer for you on whether it would.
Why would that have to satisfy the VPA? I mean, the legislature would not be amending the text of 211. It would be, I guess, passing legislation that has an impact on a rule that's been issued by the commission. At least in my mind, rules and enforcement actions are not VPA protected.
Correct. I agree that the rule itself is not VPA protected. But I think anytime you're kind of tinkering with how a voter proposition works, you have to at least, the threshold question is it amending the initiative? And so I suppose there would be 2 questions. One is that actually amending the initiative? And 2 is, if so, does it further the purpose? I don't have an answer for you on that question. On D, again, I think this is a classic case for constitutional avoidance. We don't jump right to the conclusion that the voters intended to take away the legislature's power to legislate, but buried that in a section about rulemaking oversight. Instead, we look at whether there is a plausible interpretation of subsection D that does not violate the separation of powers. And here it's plausible that the voters wanted to shield the commission from the Administrative Rules Oversight Committee.
I have a hard time believing that any ordinary voter going to the polls would read legislative governmental body and think, aha, that refers only to the Administrative Rules Oversight Committee. I mean, most voters probably couldn't even tell you what that is or even know that it exists. So what do I do with that? I mean, I think we're looking at Prop 211 does not define the term legislative governmental body, so I think we're just looking at how that term would have been commonly understood by the electorate. And when I have doubts that anyone probably even knows what the Administrative Rules Oversight Committee is, let alone thought that term referred to it, how do I get around that?
Because I think the other possible interpretation is that the voters thought that they were taking away the legislative power to enact laws. That's the argument that's being made, and I think that's more implausible, and that the voters thought that when they were doing that they buried that section in a section about enforcement actions, rules, and an APA exemption. I mean, I understand your point about what the voters knew, but I mean, this section is a pretty technical section, right? It refers to Title 40, I'm sorry.
Sorry, does the committee even have the power to legislate? My
Does-
understanding is that it's made up of 5 members of the House, 5 of the Senate, the governor or her designee, and they just sort of review and comment on administrative rules. So I don't really see a legislative power there, which I think at least in my mind, I may need to see looking at that term that's in the Act.
So that group does not have the power to legislate, but it is a legislative governmental body. And I don't think there's any dispute that it is a legislative governmental body.
So
it is a body within the legislative branch.
I'm sorry, Ms. Fraser, I didn't mean to.
No, I'm sorry.
You can finish.
I'm finished. I'm happy
Okay.
to answer your question.
And the reason I'm interrupting is because I'm so confused. If we interpret the statute the way you're suggesting, that legislative governmental body applies only to this Rules Oversight Committee, then why did you oppose an injunction below saying that 974D doesn't prohibit the legislature from acting?
Because the injunction that they're seeking is to enjoin all of Prop 211. And so if an injunction said essentially that, then well, it's hard to imagine what that injunction would look like. Who would even be enjoined?
So before us, assuming we get over the threshold of standing, which is why I wanted to talk about standing first.
Sure.
Not to keep beating that dead
I'm sorry
horse.
about that.
But assuming we get over the threshold of standing, then do you oppose a ruling from us that would say 974D does not prohibit the legislature from doing things that are VPA consistent?
No.
Then why do we spend so many pages on that?
Because the plaintiffs are asking to enjoin.
But you guys.
Because of the requested remedy. The plaintiffs are seeking to enjoin all of Prop 211 based on D. And we think that interpretation of D, that their interpretation of D is incorrect. That's why we're spending so much time on this, because the only remedy that they're seeking is to enjoin all of Prop 211. They're not entitled to that.
Severability. So I can see you spending a lot of pages on severability, but you agree with them that if 974D prohibits the legislature from acting, it's unconstitutional.
If it prohibits the legislature from legislating, yes, it's unconstitutional. But this doesn't prohibit the legislature from legislating, and you don't strike down all of D, because D doesn't just apply to legislative governmental body or official. First of all, there's the second sentence of D, which no one's challenging, which gives the APA exemption. They're not challenging that. They're not challenging its application to the Attorney General or to the Governor's Regulatory Review Council. So they're not entitled to the relief that they are seeking. That phrase, legislative governmental body, is designed, and the reason it doesn't say AROC is so that it's not so easy to avoid. This ensures...
So I read it the first time before the benefit of all your briefing, which just all of you guys, not just you, made me so confused. They wanted to make sure boards of supervisors, city councils didn't step in. They used a broader term to refer to any of the various legislative bodies that we have here in the state, but not... I have a hard time getting to this, well, no, it's just this very select subcommittee of the 2 legislative bodies in the government's office.
So it's designed so that,
Office.
I'm sorry, it's designed so that the legislature can't evade, if we had just said the AROC, then the legislature could evade that by creating a new entity and giving it different powers and a different name, and then they could avoid this.
You could have said a legislative subcommittee tasked with reviewing agency regulations.
Sure, but I think if the voters actually intended to prevent the legislature from legislating, which is what their contention is, they would have said so directly. They would have said that much more clearly.
Would you concede, and when I say concede, you need to be on guard because that's always dangerous, so would you concede that legislative governmental body, just a plain natural reading without referring to it, would normally encompass the legislature?
I can't answer that because, again, the context
You can't
is...
or won't.
Well, I'll say this, that we know, again, from those cases I explained earlier, that context is a primary determinant of meaning. The Supreme Court said this year in Drummond, it is a primary determinant of meaning. It's not a secondary tool we use. It is the primary tool we use because words have meaning in context, right? And so... we know, just to pick a silly example, when you use the word right,
So is this
R-I-G-H-T.
context here that tells me that legislative governmental body means something other than our main legislative governmental body, the legislature?
The context here is that this phrase only applies to the commission's rules and any commission enforcement actions. The legislature generally doesn't legislate about rules and enforcement actions. It doesn't have oversight over those, but AROC does have oversight over those.
So,
and the second,
sorry to interrupt. The second sentence of D exempts the commission from the Administrative Procedures Act.
correct,
right? Which includes the oversight committee, right?
correct.
So why would the people exempt the committee in the second sentence if they've already done that in the first?
So these two sentences do different things. There is some overlap the way things are structured right now. The second sentence also exempts the committee from the other portions of the APA that do not relate to rulemaking oversight, but are things about notice and comment rulemaking and that kind of thing.
Aren't you rendering the reference to legislative governmental body superfluous if the second sentence is just taken care of?
No, no, Your Honor. Again, because the first sentence is designed to make sure that the legislature can't evade this by merely recodifying AROC or something similar outside of Title 41, Chapter 6 and 6.1. So the first sentence, again, is designed to make sure that there's no mischief going forward. And I can give you a bit of history that I think might explain this, which is the commission initially had an APA rulemaking exemption, and then the legislature took that away. It was referred to the people, and so the voters here decided to put it back and further insulate the commission from political interference by the elected branches. So I think that history shows that this context matters. Again, if the people wanted to strip away the legislature's power, which is what they're contending, they wouldn't have buried it in a section about rulemaking and APA exemption.
I don't know how much time you're planning on.
I promised him 8 minutes, so I will.
Want to talk about severability real quick?
Is that a
Sure.
merits or a standing issue?
Severability. Severability? I'm planning on covering severability, if that's what you're asking. So on severability, as you discussed earlier, there is an express severability clause. Clean Elections v. Myers essentially provides a presumption of severability. It says that all doubts are to be resolved in favor of severability when the voters chose to include this. If you take away D, or first of all, you shouldn't take away all of D because most of D is not challenged. The only phrase that's challenged there is legislative body. But even if you take away that or other parts of D that are not challenged, all of the substantive parts of Prop 211 survive. All of the requirements for disclosure, all of the rulemaking powers, all of the requirements about reporting all of this stuff and the records you need to keep, all of those survive. And so the D, if there is a problem with it, the offending portions of D, not all of it, but the offending portions can easily be severed. I want to make sure you have enough time to talk standing, so I will sit down and turn things over to Mr. Aerosmith. We ask that you affirm. Thank you.
Thank you, Mr. Frazier.
Good morning. May it please the court, Nathan Aerosmith on behalf of the Attorney General, Chris Mays. I'll be arguing standing, as Mr. Frazier said, on behalf of all appellees. So, Judge Morris, I want to jump to something that you had asked Mr. Frazier about, which is, the concept of agreeing to an injunction if we agreed on a meaning. And I think that highlights why standing is so important. The plaintiffs haven't alleged any actual injury, imminent harm, or existing facts sufficient to create an actual controversy. And I think that that's particularly important here where we're talking about the legislature attacking a law passed by the voters. So if, taking that concept, if we ignore standing, or if the legislature has standing here, what's to stop in the future if the legislative leaders and some executive branch officials agree that they don't like a voter-approved law? What's to stop them from agreeing to some kind of injunction to prevent the voter-approved law from going into effect?
I mean, the legislature has alleged that this is currently restricting our lawmaking power, at least D. How is that not sufficient for purposes of standing?
So Your Honor, that is a legal conclusion about what the text means. And the court does not have to accept the plaintiff's legal conclusions about what a statute means.
So if we do accept, just hypothetically speaking, their definition, they have standing.
No, Your Honor, that I think then gets into the question of ripeness. And so that's where, assuming you accept their reading of 974D, well, what is the actual controversy? They haven't alleged, they've been very clear that this is a facial challenge, their injury arises from the text of Prop 211 itself. They haven't alleged any set of existing facts demonstrating a present actual controversy that requires judicial determination.
Well, I do think in a way we do have to accept their allegation, because Sears v. Hull says that in the context of standing, we don't get into the merits. We take what the plaintiffs has said is given, and we determine whether that gives rise to standing. So I know you've asked us to interpret the statute in terms of standing and have argued that your interpretation is better, but I'm not sure we can do that under Sears v. Hull. What's your reaction to that?
Yeah, so I think that this is distinguishable, and I understand the confusion and the sort of messiness, because there's statutory interpretation involved in both the standing and the merits question. But the statutory interpretation analysis for standing is, does this text that they say injures them, does it in fact mean what they say it means? Does it injure or apply to the legislature on its face? That's a separate question from then looking at, is this constitutional? So for example, some of the cases that they rely on for this proposition that the mere enactment of a statute can cause an injury are like a Fifth Amendment regulatory takings case or a tax case, the Fan versus State. But what those cases are really talking about is ripeness. There still has to be an analysis of, does the zoning ordinance apply to the plaintiff? Does the tax apply to the plaintiff? If not, that plaintiff doesn't have standing to bring a facial challenge to that regulation. And the court doesn't have to accept a plaintiff's assertion that a statute means a particular thing or that a statute has a particular effect.
Would the Attorney General have standing to challenge D?
Would the Attorney General have standing
It very clearly refers to the Attorney General and prohibits her from taking certain actions right now.
I honestly had not considered that. Again, the role of the Attorney General is to defend the laws of the state, and I can't imagine a situation in which she would attack the law.
What additional steps does the legislature need to take here in order for this to be ripe?
Well, I can't tell them what to do, but they certainly need to do something more to establish an existing set of facts that's right for determination.
You need to tell us what you think they need to do that is missing in order for ripeness to exist.
Right. So I think
do they need to pass a statute that then gets struck down?
No. So I mean, that's certainly something they could do. They could draft a bill. They could introduce a bill. They could take any number of actions to let the court know.
Either one of Toma or Peterson had just drafted a bill, introduced it, but as we know, lots and lots of bills are introduced that never even make it to committee. But that would have been sufficient to confer standing in this case?
That may have been. The court needs some sort of set of existing facts to determine whether to determine the validity of the statute. You need something to apply.
What did the Supreme Court require in Arizona State Legislature on the redistricting case?
What did it require for standing?
Yeah.
Well, so in that case, I think the law is, the law at issue there was significantly different. And I think that, their argument that
there's some broad language in there about just institutional injury,
right. But
taking away this power is the injury that gives standing. So
yes.
I don't recall, was there a alternate thing that was passed?
So Proposition 106 amended Article 4, Part 2, Section 1 of the Constitution, which says, the Senate or House shall be composed of, X number of members. And it used to say, from 30 legislative districts established by the legislature. Right. Proposition 106 struck the words by the legislature and inserted the words pursuant to this section, and then inserted the description of the independent redistricting case. Right. So that on its face removes the power from the legislature and places it with the redistricting commission.
And the SG had argued, well, they didn't propose an alternative slate or an alternative map that was then rejected, and the Supreme Court said they didn't have to do that in order to have standing.
Right.
Nullification exists once the law that is impinging or imputing the lawmaking power. Once that's passed, that's your institutional injury. So why is this different?
There wasn't any dispute in that case that the voters had taken a a task that the legislature could
But that
previously
goes to the
do.
merits of your argument. So, I mean, assuming we reject the 974D doesn't actually restrict the legislature argument, which I'm not saying we're doing that, but if we're back to the kind of hypothetical I had with Mr. Frazier, if we say legislative governmental body means the legislature, then you would agree they're standing.
No. Again, that goes to the question of what is the actual injury. There's no
But we have
there's
a
no
law that says the legislature can't pass any law.
Well, that's not what it says, and the court is not required to accept their
What
interpretation.
does it say? If we say legislative governmental body means the legislature, what does 974D say?
It doesn't prevent the legislature from legislating. It refers to prohibitions and limits on rules or enforcement actions, which the legislature doesn't have any role in those now to begin with. The legislature cannot overturn an administrative rule. The legislature cannot overturn an agency action. So it doesn't.
Wait.
It doesn't say.
You're saying the legislature can't overturn an agency action or a rule separate and apart from the initiative process?
The legislature would, could presumably pass a bill designed to, reverse something that an agency had done, but they can't directly, repeal a rule, or that's what I'm saying. The legislature doesn't have oversight over administrative rules. That's the Governor's Regulatory Review
Oh,
Council.
okay, now I understand what you're saying. All right.
Yes.
But the legislature could say, just by a simple act, say, we vacate this agency rule. And if they passed it and the governor signed it, that would have the force of law, right?
I'm not sure. I'd have to dig a little bit more into
Fair
that
enough.
as to whether that would be possible.
I think your time's up.
Okay, thank you. We would ask that the
Mr.
court affirm.
Thank you.
Judge Catlett, Ms. Olson was going down the same road you were on the independent redistricting case and what that meant. And the reality is the Supreme Court said you don't need to take futile actions. So, and in addition to the cases that have already been cited, obviously refer you to ASBA, Mills, and even the ACBA case from last week that talks about actual controversy and looking at the plain language. If you actually need to look about the future, let's look at the past. Title 16, originally from the state legislature, and controlled campaign financing until we got up to the Clean Elections Act, or Clean Elections Act. In addition, before even Title 16, we had the Elections Clause. The Elections Clause gave that power to the legislature. So to say that the legislature, acting as a whole, is not going to regulate campaign spending, especially in this day and age in the future, is a fiction, and we don't have to go through a futile act. All we have to do is look at the past itself. So I would like to take some of the arguments backwards, if you don't mind. We've talked about legislative bodies, and Judge Morris, you specifically asked, what did the language say? And I think that's actually important for the record. The Commission's rules and Commission enforcement actions pursuant to this chapter are not subject to the approval or any prohibition or limit imposed, underlined, by any other executive or legislative governmental body or official. Now, we know that the regulatory bodies that the Commission and the Attorney General are referencing, they're not able to do imposition on anything. They have to be reviewed, but they actually don't have any authority or impose or interfere. The only body in this context that has the power to do that is the legislature or some of the sub-legislatures through the county, the supervisors, and we've already talked about 978. So if you have to have the meaning there as to what does imposition mean, and if you actually look at what Mr. Frazier talked about before, what's D, this is a specific answer, what is D meant for? It's so the legislature cannot rework GERC and the other one, AORC, to be able to interfere with the Commission's laws. That was what was argued previously. So that's the legislature taking action. That's not GERC. That's not AORC. In regard to the Attorney General, that's obviously falls within the executive, and whether or not the Attorney General would be able to come to this court and seek recourse is a different issue.
Did you seek an all or nothing injunction?
We
In other
did.
words,
Go ahead.
we strike the thing down in its entirety, or you get no relief?
No, Your Honor. I mean, we want, it is a strike or nothing
I know
because.
you're asking for that.
Yes,
I know
Your
you've
Honor.
asked for it to all be struck down.
Correct.
I'm not previewing what we're going to do at all,
Right.
but if we don't do that, have you asked for a more narrow injunction in the alternative?
We have not asked for a more narrow injunction in the alternative. Obviously, the relief, the court is well aware that when the relief, it's basically whatever to effectuate the court's decision in this matter. So obviously, you could subset it that way. But the reality is in this case, the Rudolph argument, as well as the fan talking about severance, comes into play, and this is not severable. The people wouldn't have voted on it, and it wasn't buried within a different regulation. It was front and center in the pamphlet and the ballot itself.
Can you give, I want to turn to severability.
Yes, Your Honor.
Because you only got a minute 40 left. What is your best case to suggest that we should sever or we should not sever? I couldn't find a case under similar circumstances where we have a severability clause where a court said, you know what, I'm going to look at the totality of this and ignore the severability clause and strike down the entire legislation.
FAN, Your Honor, I'd ask you to go read FAN. So in FAN, it talked about the workability, talked about the Rudolph factors and how it wasn't workable, talked about institutional injury, and it also talked about the things we've already mentioned about what the voters thought in this context and whether or not it would be absurd to have to strike down, in this case, 974D and 974A, and allow for an administrative agency to effectuate all these rules and regulations underneath the other portions that are not struck down and still give meaning to what the voters actually wanted here. They wanted to have enforcement. They wanted to have tools. And I'm going to your argument, Your Honor, and I would point you to the transcript, but the VRT counsel said specifically in regard to D and A8 that the purpose, the voters specifically meant to have this agency, this commission, as independent as possible from other elected officials. That was what VRTK has said. And if you look at the actual rules, and I'm sorry that we didn't get into a lot of them, but if you actually look at the rules, what is the commission doing? They're looking at how VRTK actually analyzed this for some sort of presumption of legality as to what 211 meant. So with that, Your Honor, I would ask that you maintain the balance within the state of government within Arizona and overrule the previous decision. Thank you, Your Honor.
All right, thank you, counsel, for your arguments and your briefs. We will take the matter under advisement and issue a ruling in due course. We stand adjourned.